Good morning, beautiful people. I realize that I look like I'm dressed in the exact same thing that I was here in yesterday. And full disclosure, I am. I am. I am. I am in the same clothes that I was in yesterday. However, comma, I've changed my clothes several times since yesterday. You just wouldn't know that because you didn't see me. I wore this yesterday for just about an hour. And then I changed, and then I changed it again, and then I changed again. And now it's officially the day, so obviously had to put it back on. But I have technically changed twice since you saw me yesterday. Not that bad off yet, okay? It's not one of those weekends. But it is good to see you all. Shout out to everybody who's watching. Hit the like button. Share this live. I want to say a shout out to Lily Eternal for hitting up the Discord last night. I was passed out. I was all messed up yesterday, so my sleep schedule was all messed up. But I was passed out. But Lily Eternal hit the Discord yesterday and said, "There's a lawsuit that has been filed by Minnesota law enforcement, not the mayor, not the governor." Okay, this is different, separate, not the mayor, not the governor, law enforcement, state law enforcement, and the county prosecutor have filed a lawsuit against Kristi Noem and ICE, and they have already been awarded a TRO. But before I get to that, shout out to another looter. Y'all hold me down and y'all hold each other down too. I meant to say something yesterday, but I just didn't have the wherewithal to pull it together. So shout out to looter Angie Lady. And this is for all of you, okay? This is going to address your handle in the chat, your at in the chat. Are you ready? Everybody say thank you to Angie Lady in advance because this is going to address your at. You know how it keeps changing. You know how it annoys all of us because I get used to calling you one thing and then it changes it and it calls you something else. And we've got the whole at symbol going on instead of just a name. So I don't think the at symbol necessarily goes away, but Angie Lady has cracked the code and I'm going to give you the instructions right now. And if you want to take a second to go and change it, you can do that. Go to your YouTube studio. If you're thinking, I have a YouTube studio, you do. You have a name, you have a channel, whether you use it or not. So you have YouTube studio. So you're going to go to YouTube studio. Okay, so click on your icon. Let me get into YouTube so I can guide you through this as well. Click on your user icon. Okay, from my understanding, it's not settings. You're not going YouTube icon where you see your name and you usually go down to settings. Well, before that, you should see Google account, switch account, sign out, YouTube studio. You're going into YouTube studio according to these directions, which I know Angie Lady has tried out and successfully changed her handle. Select customization on the left-hand menu. Edit your handle in the basic info tab. You can find and edit your unique at handle. You can also change the larger prominent channel name that appears on your channel page and videos. When you're done changing it, look up to, if you're on a desktop, about the right-hand side, but look for the publish button when you're done in the upper right-hand corner to get the changes to save. So in the YouTube app, you're going to click on your user icon. You're going to scroll to YouTube Studio. If you're on your phone, it will prompt you to install it. If you're on your desktop, it'll just switch you over. It'll open a tab and switch you over to YouTube Studio. Select customization in the left-hand menu. Edit your handle or edit your display name. Hit publish to save the changes. Okay? So shout out to Angie Lady, who I also still need to make a mod. I'm just remembering. I haven't watched the replay from yesterday. So just a little bit of housekeeping there to take care of before I forget off top. So yeah, handled that. Okay. And as I said on the post tab this morning, shout out to Curtis 2S King, as we refer to him here on the channel. Happy belated birthday. Okay, so we've got that out there. But yes, thank you, Lily Eternal, for letting me know that this lawsuit has been filed. And again, this is not the governor, this is not the mayor. They both already have court action going against Kristi Noem and ICE. So this is new, and this is as of last night. Demetrius, thank you for the $5 contribution. Let's hit that goal. Let's hit that goal this morning. And shout out to the replay gang for those of you who are at work or still asleep, wherever you are in the world and unable to watch us live. Shout out to all of you who will catch it in the replay. This is the Minnesota Bureau of Criminal Apprehension and the Hennepin County Attorney's Office. They are the ones bringing this complaint. This complaint is against Kristi Noem in her official capacity as Secretary of the U.S. Department of Homeland Security, John Condon, Executive Associate Director, Todd Lyons, Acting Director of U.S. Immigration and Customs Enforcement, Marcos Charles, in his official capacity as Acting Executive Associate Director, Enforcement and Removal Operations, Rodney Scott, in his capacity as a Commissioner of U.S. Customs and Border Protection, Gregory Bovino, in his official capacity as Commander of the U.S. Border Patrol, David Easterwood, in his capacity as Acting Director, St. Paul Field Office, Pam Bondi, in her official capacity as Attorney General, Kash Patel, in his capacity as Director of the Federal Bureau of Investigation. So the Bureau of Criminal Apprehension, many states have a statewide law enforcement body. And for Minnesota, it's the Bureau of Criminal Apprehension. You could look at it as the equivalent, the state equivalent to the FBI, or the highest law enforcement body in the state land. Fuck that guy. 1000%. I've got a scripted video out this morning because I've been up since 3:30. I've got a scripted video out this morning. The 7 Democrats who voted to continue bloodshed of Americans. So make sure that you check that out today as well. So shout out to everybody who's watching. We've got a good little gang in here for a Sunday morning. Shout out to you wherever you are watching in the country or in the world. It's good to have you. Hit the like button, share the live. We're just getting into this document. This is a new lawsuit filed by the Minnesota Bureau of Criminal Apprehension and the Hennepin County Attorney's Office. Hennepin County is in Minnesota. 7:36 in the morning. I've been up since 3:30. Okay, give me a moment. But Hennepin County has jurisdiction over Minneapolis. Probably seen their prosecutor, Mary Moriarty. Probably seen dude from the Minnesota Bureau of Criminal Apprehension. These folks in press conferences. Thank you. Shout out to Lily Eternal for letting me know that this dropped, and I've got docket alerts set. So this is brought by them, not the mayor, not the governor. Plaintiffs, the Minnesota Bureau of Criminal Apprehension, and Hennepin County Attorney's Office bring this case for declaratory and injunctive relief to vindicate their right to access evidence related to a fatal shooting by federal officers, which took place on a public street in Minneapolis on January 24, 2025. So, I mean, shout out to them for doing this the day that it happened, because I think one of their major failures in the Renee Good situation is that they haven't done this in her case. If they have, and you're aware that they have, check me. But it's one of the things that I've been waiting for, is for them to sue the federal government for access to and or possession of the evidence that they took in the shooting killing of Renee Good, because they've already made it clear in private memos that have been leaked and in public statements, nothing to see here. We're not going to be investigating this as a civil rights violation or as a crime, period. So they should not continue to possess the evidence in that case. So I've been waiting for them to do something on that situation. They have not as of yet, but I hope that they do. So, defendants' apparent determination to deny state and local law enforcement access to relevant evidence is contrary to core principles of federalism embodied in the U.S. Constitution and poses an unreasonable interference with plaintiffs' ability to carry out their sovereign right and responsibility to investigate possible violations of state law with the state's borders. I think that's supposed to say within the state's borders. On the morning of January 24, 2026, federal officers shot and killed a man in the area of 26th Street East and Nicollet Avenue in Minneapolis. Those officers were present in the area as part of an unprecedented deployment of federal immigration enforcement agents from numerous agencies of defendant U.S. Department of Homeland Security to the state of Minnesota, including into the cities of Minneapolis and St. Paul, known as Operation Metro Surge. From initial reports, it appears a victim may have been in the process of being restrained by multiple federal officers at the time of the fatal shooting. As is typical of an officer-involved shooting involving a federal officer, BCA personnel headed to the scene to investigate the incident. I know from watching their press conference that they made the federal government aware that they were going to be heading to the scene. Preliminary investigatory measures include establishing a perimeter, preserving the scene, taking photographs and measurements, identifying those involved and witnesses, taking statements, and collecting physical evidence. But federal personnel purported to order Minnesota law enforcement to leave, denying them immediate access to critical evidence necessary to investigate crimes under state law. According to reports, federal personnel apparently seized cell phones and detained witnesses. It is unclear whether federal personnel otherwise processed the scene, let alone How carefully? Then, just a few hours after the shooting, federal personnel left, allowing the perimeter to collapse and potentially spoiling evidence. That is a huge accusation. Everything so far in this document is damning and jaw-dropping and unprecedented. A local jurisdiction in the United States of America is suing the federal government law enforcement agencies, alleging that they are de facto obstructing justice. This is from yesterday. They wasted no time, same day of the shooting, state and county law enforcement suing the federal government for de facto obstruction of justice. It is stunning and unprecedented. And I know people use that word a lot, but this is unprecedented. But they've already learned. This is what they learned that the federal government would do. They learned this from the Renee Good murder, that they will obstruct, that they will not treat a scene or evidence with the care that is required for a proper investigation. Spoliation of evidence is a massive accusation, carries a lot of weight. Contrary to longstanding procedures and accepted norms of state and federal cooperation, it appears federal authorities have taken exclusive possession of evidence from the scene. Unfortunately, based on the government's refusal to allow BCA to participate in this and other similar investigation, singular, and another similar investigation, there is every reason to believe that defendants will continue to deny plaintiffs access to that evidence absent this court's intervention. I'd also like to point out from watching their press conference, not related to this. This was their press conference after the shooting. I didn't know that they had filed this till I woke up at 3:30 in the morning and saw Lily Eternal's post in the Discord. But in their press conference after the shooting yesterday, not only did they notify federal law enforcement that they were headed to the scene, they went and got a warrant. And they were still denied access to the scene. So they did everything that they were supposed to do. They notified federal law enforcement, we're on our way, and this is what we expect to do when we get there. They got a warrant, a detailed warrant. We have a copy. We have 6 documents to look at attached to this lawsuit, and this all just happened last night. As I said, the judge has already handed down a preliminary order. There is a hearing tomorrow. So this is going to move very fast, and both sides are going to be extremely aggressive. As a matter of basic federalism, the state of Minnesota, through BCA, has core sovereign interest in investigating and enforcing its own criminal laws. Criminal laws. State law enforcement agencies have both a right and responsibility to assist in that endeavor in the interest of protecting the citizens of Minnesota and everyone present within its borders. Defendants' actions to abruptly leave the scene, apparently with critical evidence, in order to deprive plaintiffs of access, violated core principles of federalism and the 10th Amendment, which this lawsuit seeks to vindicate. This is also not the first occasion on which federal officers have committed a fatal shooting within the state's borders during their recent unprecedented show of force, nor is it the first time defendants have willfully interfered with the ability of the state and its subdivisions to investigate such a fatal shooting. On January 7, 2026, 37-year-old citizen Renee Good was shot and killed in her car by a federal agent in Minneapolis, Minnesota. Video footage capturing the events surrounding the killing have been widely publicized by the media. On January 8, 2026, the federal government revoked plaintiff BCA's access to evidence of the shooting, reversing an earlier agreement that a joint investigation would be undertaken and that the two sovereigns would share information. According to public reporting, multiple officials at the DOJ resigned due in part to the federal government's failure to follow protocol by refusing to investigate the federal agent involved in the killing and instead pushing to investigate the victim's family and Minnesota officials who opposed DHS's actions in the state. This is so damning. This document is stunning. Absolutely. I am absolutely rocked. The officials who resigned include an FBI agent who was pressured not to conduct an investigation into the officer's use of deadly force, despite such an inquiry being routine in officer-involved killings. Despite the lack of any apparent federal investigation into the federal officer's actions, multiple high-level federal officials have declared the federal officer's actions justified. State and local enforcement continue to investigate the fatal shooting of Good, despite the federal authorities' ongoing failure to cooperate. I, 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 I am stunned. I'm really stunned. I know I just said that, but this is stunning. They go through jurisdiction and venue, who the parties are, who the BCA is, who the Hennepin County Attorney's Office is, defendant Kristi Noem, defendant John Condon, cabinet agency, U.S. Department of Homeland Security, defendant Todd Lyles, defendant Immigration and Customs Enforcement, defendant Marcos Charles, defendant Rodney Scott, Border Protection, Gregory Bovino, Border Patrol, David Eastwood, Field Officer, the St. Paul Office, Pam Bondi, Kash Patel. Count 1, 10th Amendment of the U.S. Constitution and Principles of Federalism. Plaintiffs reallege and reincorporate by reference everything they said so far into this next section. Federal courts possess the power in equity to grant injunctive relief with respect to violations of federal law by federal officials. I'm just absolutely gobsmacked by this document. They are 1,000% accusing federal law enforcement of obstruction of justice. The 10th Amendment provides that the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Under our system of federalism, policing and crime control remain one of the most basic rights reserved to the states and their municipalities. Indeed, we can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and vindication of its victims. The power to establish the ordinary regulations of police has been left with the individual states and cannot be assumed by the national government. Local control of law enforcement is essential to the protection of liberty and government accountability. Because the police power is controlled by 50 different states instead of one national sovereign, the facets of governing that touch on citizens' daily lives are normally administered by smaller governments closer to the governed. The framers thus ensured that powers which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people were held by governments more local and more accountable than a distant federal bureaucracy. The Federalist, James Madison. I just love it when the Federalist is quoted against the federal government. It just does something for me. They are not playing around. The framers, Madison, the Federalist. Fuck you, fuck you, fuck you. I love it so much. I just love it. I love it. Oh, it's so good. This is incredible. This is an incredible historic document. Defendants' initial attempt to bar BCA access to the scene of the shooting and their taking into custody of evidence before plaintiffs could gain any access to it violated plaintiffs' core sovereign interests in investigating and enforcing state criminal law. The fact that federal authorities attempted to bar BCA and then let the scene collapse directly threatened the availability to plaintiffs of evidence needed in a criminal investigation. The actions of federal authorities to date indicate defendants will continue to withhold, destroy, alter, or conceal, or allow to be withheld, destroyed, altered, or concealed evidence, if not restrained from doing so. Plaintiffs have a non-statutory right of action in equity to enjoin and declare unlawful official action that is unconstitutional. As described above, defendants' actions violate the 10th Amendment and core principles of federalism enshrined in the U.S. Constitution, which constrain defendants' actions. Count 3. Arbitrary and capricious, not in accordance with law, and contrary to constitutional right, power, privilege, or immunity. This is delightful. DHS, ICE, CBP, and U.S. Border Patrol are federal agencies subject to the requirements of the APA. The APA provides a cause of action in federal district court for any person aggrieved by final agency action. The ongoing denial of access evidence constitutes final agency action that is reviewable by this court. The APA requires a reviewing court to set aside agency action that is arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. This is contrary to constitutional right, power, privilege, or immunity that is in excess of statutory jurisdiction, authority, or limitations, or short of statutory right, or that is without observance of procedure required by law. Defendants' ongoing denial of plaintiffs' access to relevant evidence is arbitrary and capricious, not in accordance with the law, and contrary to constitutional right, power, privilege, and immunity. Count 4, unlawfully withheld and unreasonably delayed agency action. By refusing to provide plaintiffs with access to evidence related to the shooting, which is urgently needed for plaintiffs to discharge their duties and carry out core state police powers, defendants have unlawfully withheld and unreasonably delayed agency action in violation of the APA. Prayer for relief. Wherefore, plaintiffs ask that the court grant the following relief. Declare that defendants' ongoing denial of plaintiffs' access to evidence relevant to the fatal shooting on January 24, 2026 is unconstitutional and unlawful. Preliminarily and permanently enjoin defendants from destroying, altering, or concealing any such evidence. Preliminarily and permanently enjoin defendants from continuing to deny plaintiffs access to any such evidence. award the plaintiffs their costs and reasonable attorney's fees, and order such other and further relief as this court deems just and appropriate. As signed by the office of Keith Ellison, the Attorney General for the state of Minnesota, by Pete Farrell or Pete Farrell. Okay, so that's the complaint. Then we have a motion for a temporary restraining order. Plaintiffs, the Minnesota Bureau of Criminal Apprehension, and the Hennepin County Attorney's Office respectfully move, pursuant to Federal Rule of Civil Procedure and District of Minnesota local rules, for a temporary restraining order on an emergency basis to enjoin defendants from destroying or failing to preserve evidence related to a fatal shooting in Minneapolis involving federal officers from the U.S. Department of Homeland Security that took place on January 24, 2026, near the intersection of 26th Street and Nicollet Avenue. This includes evidence that defendants and those acting at their direction and under their authority took from the scene of the shooting, thereby preventing the BCA from inspecting it. Plaintiffs have a sovereign interest in exercising their police powers and in investigating potential violations of Minnesota's criminal laws. This interest is safeguarded by the U.S. Constitution, including the 10th Amendment and longstanding principles of federalism. Defendants' hasty removal of evidence from the scene of the DHS-involved shooting, contrary to ordinary protocols and the state's sovereign right of parallel access to that evidence, violates that sovereign interest of the state and creates an unacceptable risk that the evidence will be permanently destroyed or altered before plaintiffs are able to litigate their right to access that evidence. Unless immediate relief is granted to enjoin defendants from destroying or altering evidence related to the shooting and or taken from the scene, plaintiffs will suffer irreparable harm to their ability to investigate and enforce state criminal laws and protect the people of Minnesota. As set forth in detail in the accompanying memorandum of law, plaintiffs are entitled to emergency relief because, 1, they are likely to succeed on their claim under the U.S. Constitution. 2, they will suffer irreparable harm without a TRO. And 3, the interests of the parties and the balance of the equities weigh heavily in favor of a TRO, preventing the federal defendants from destroying evidence related to the fatal shooting. Wherefore, plaintiffs respectfully request that the court immediately enter a TRO to enjoin defendants together with their employees, agents, and anyone acting in concert with them from destroying or altering any and all evidence related to the fatal DHS-involved shooting on January 24, 2026, including but not limited to any evidence or potential evidence taken from the scene of the shooting and any evidence or potential evidence that defendants are holding in exclusive federal custody. A proposed temporary restraining order is being submitted with this motion. In addition, plaintiffs have notified U.S. Attorney's Office for the District of Minnesota via email that they are filing this motion, and they have asked the Civil Division Chief to confirm receipt of that email and to advise who will be representing the federal defendants as soon as possible. Memorandum in support of the TRO. The BCA and the Hennepin County Attorney's Office moved this court to issue a temporary restraining order preventing the federal defendants from destroying evidence related to a recent fatal shooting in Minneapolis. Events are evolving, but here is what we know. Earlier this morning, federal officers shot and killed a man in the area of 26th Street East and Nicollet Avenue in Minneapolis. From initial reports, it appears the victim may have been in the process of being restrained by multiple federal officers immediately prior to the fatal shooting. As BCA Superintendent Drew Evans detailed in an accompanying declaration, BCA personnel headed to the scene to investigate the incident, as is typical with officer-involved shootings involving federal agents. Preliminary investigatory measures normally include establishing a perimeter, preserving the scene, taking photographs and measurements, identifying those involved and witnesses, taking statements, and collecting physical evidence. Attorneys and other staff from the HCAO also responded and collaborated. That's the Hennepin County Attorney's Office. Also responded and collaborated with investigators throughout the day. The HCAO has jurisdiction to prosecute felonies that occur within Hennepin County, to convene and present to the grand jury and to seek subpoenas to secure witnesses and evidence for criminal proceedings. In the case of use of deadly force by Minnesota peace officers, the law requires that a report of the investigation be submitted to the prosecutor for the county in which the incident occurred. As the prosecuting authority with jurisdiction for any crime that may have occurred, the HCAO works closely with investigators to ensure that evidence is preserved and handled properly. But federal personnel purported to order BCA personnel to leave. According to reports, federal personnel may have seized cell phones, taken other evidence from the scene, and detained witnesses. It is unclear whether federal personnel otherwise processed the scene, let alone how carefully. Then, just a few hours after the shooting, federal personnel left, allowing the perimeter to collapse and potentially spoiling evidence. From a law enforcement perspective, this is astonishing. Yeah, it is. Yeah, from a civilian perspective, it's pretty fucking astonishing. The federal government's actions are a sharp departure from normal best practices and procedure, in which every effort is taken to preserve the scene and the evidence it contains. Instead, by first attempting to bar BCA and then letting the scene collapse, the federal government appears to have taken measures that directly led to the destruction of evidence. Now, more than ever, the public needs confidence that this investigation is being handled in a careful, neutral, and professional manner. Plaintiffs are concerned that, absent this court's order, defendants will continue to willfully fail to preserve evidence, including evidence federal officers took from the scene. If that occurs, plaintiffs will lose access to that information forever. Plaintiffs therefore respectfully request this court order defendants not to destroy any of the evidence they have collected or will collect in the next 14 days. This TRO should not be necessary. This TRO should not be necessary, but unfortunately, events today suggest this court's intervention is essential to preserving the status quo and to protecting the state's sovereign powers to investigate a fatal shooting. They cover the legal standard, their argument that their constitutional powers are being threatened. A lot of this is repetitive, 10th Amendment, and so forth. Going through the Constitution, going through some rulings of the Supreme Court, which is very good. Again, quoting the Federalist, this is very good. Notably, this case does not ask the court to mediate any clash between the state's rights under the 10th Amendment and the federal government's own constitutional powers to enforce its law. At present, plaintiffs seek only to preserve and examine evidence. Permitting plaintiffs to perform that modest task does not conflict with any federal law or interfere with any function exclusively reserved to the United States. Smart, because they're attacking, this supremacy clause and the vice president saying these false blanket statements of absolute immunity and federal laws and states can't. They're saying, we're not even talking about that. We have a modest request that we shouldn't even have to make, given the circumstances. They have to show a likelihood to prevail or a belief of a likelihood to prevail. They at least have to argue it. So that is in here. What merits relief? What happened today was not normal. And it suggests that the federal government may fail to preserve information that will be critical to a thorough investigation. The federal government took actions that obstructed the BCA's investigation and may have failed to protect and secure evidence at the crime scene. Crime scene. Not scene of the event, not scene of the investigation. Crime scene. And they used the word. They said obstructed. Integrity of the scene following a homicide is paramount to the search for the truth of what caused the loss of human life. But the federal government purported to order BCA from accessing a public street in Minneapolis to process evidence. Then the federal government abruptly departed the street, allowing the perimeter to collapse and likely leading to the spoliation of the scene. This astonishing series of events indicates that the federal government may continue to withhold and fail to protect evidence in derogation of Minnesota's solemn prerogative to protect the public trust. Second, plaintiffs' irreparable harm is so weighty that any harm to the federal government does not even budge the scales. But in fact, the TRO would cause no cognizable harm to the federal government. A TRO does not interfere with the federal government's ability to conduct its own investigation. Instead, it simply requires the federal government to preserve the status quo for a brief period so that a separate sovereign may conduct its own investigation. Third, the public interest strongly favors a TRO. There is no public interest in the federal government destroying evidence or obstructing the state's police powers. Meanwhile, the public interest is served by a fulsome investigation. Indeed, at minimum, a TRO is critical to preserving the status quo and allowing any litigation to proceed. For the foregoing reasons, the court should issue the proposed TRO. Declaration of Drew Evans. This is the head of the state BCA. I am the superintendent of the Minnesota Bureau of Criminal Apprehension. This declaration is submitted in support of plaintiff's motion for a temporary restraining order. The statements made in this declaration are based upon my personal knowledge, reasonable inquiry, and information made available to me in the course of my official duties as superintendent of the BCA, plus records and information gathered by BCA staff. When a law enforcement officer uses force and a person dies or is seriously injured in the state of Minnesota, agents with the BCA's Force Investigations Unit investigate the officer's actions to determine the circumstances of the incident. The BCA investigates use of deadly force, such as when an officer shoots at someone. The local jurisdiction typically requests the BCA's assistance in investigating the use of force. After the BCA completes an investigation regarding the use of force by an officer, the BCA submits a report without a recommendation to the county attorney's office with jurisdiction over the incident. Historically, the BCA has also responded to shootings involving federal law enforcement. In the past, the BCA has often handled these types of investigations without federal involvement. If federal law enforcement is involved in the investigation, the BCA has historically worked in cooperation with the Federal Bureau of Investigation to conduct a complete and thorough investigation of those incidents. On January 24, 2026, at approximately 9:30 a.m., the BCA's Force Investigation Unit responded to a use of deadly force incident involving ICE agents. The incident was reported to have occurred in the area of 26th Street East and Nicollet Avenue in Minneapolis, Minnesota, in Hennepin County. According to videos taken by onlookers at the incident, it appears the following occurred. ICE agents had contact with a subject in the area. For unknown reasons, at the current time, a struggle ensued between the subject and several ICE agents. Shots were fired and the subject was shot. It is my understanding that the subject was transported to the Hennepin County Medical Center, where he was pronounced dead. The BCA responded to the scene at the request of the Minneapolis Police Department and arrived within an hour of the shooting. BCA was at the scene before the FBI. As the BCA was responding, I was in contact with federal authorities to let them know that we would be on site for an investigation. When the BCA agents and crime scene personnel arrived, they were blocked by federal agents with the DHS from accessing the scene. The BCA continued to make contact with federal authorities, such as the U.S. Department of Homeland Security, to try to attempt to access the scene so that the BCA could gather evidence, understand what occurred, and work through our normal investigative process. DHS did not respond. The BCA team also secured a search warrant for the scene that was signed by Minnesota District Court Judge Gina Brandt at 11:54 a.m. on 1/24/26. A true and correct copy of the search warrant application is attached as Exhibit A. Obtaining a warrant to access a public space is unusual, but we thought it was necessary given the federal authorities' refusal to allow us access to the space. The BCA then presented the signed search warrant to the federal agents. Federal agents once again blocked the BCA agents and crime scene personnel from accessing the scene. In my 20 plus years at the BCA prior to 2026, I had never encountered a situation in which federal authorities blocked BCA access to an incident where there is concurrent federal and state jurisdiction. After the FBI cleared the scene without providing the BCA access, local and state law enforcement officers were unable to hold the scene, and it was overrun by individuals in the area. The BCA was thus unable to examine the scene. The BCA will continue to investigate this incident, but it is difficult to obtain evidence the BCA needs without assurance that evidence will be preserved and that we will be allowed to access it. The BCA may be unable to conduct a thorough and complete investigation without access to the evidence the federal authorities collected at the scene. In addition to the items sought in the attached search warrant, the BCA will seek access to the evidence in the FBI and/or DHS's possession to conduct an investigation. Such information includes, but is not limited to, any physical evidence collected by the FBI and/or DHS. The names of DHS agents involved and present at the scene when the shooting occurred. The names of witnesses that were identified, as well as any contact information for witnesses and any statements made or information they provided, and any firearms that were discharged or recovered. I have been informed this incident is now being investigated by DHS and not the FBI. This is not the first time since Operation Metro Surge began that BCA has been prohibited from accessing evidence that it would typically be able to access for its normal investigative processes. I have also seen images circulating on social media of the alleged gun that was used in today's shooting. It does not appear that the gun was protected according to normal law enforcement processes, and I am concerned about other evidence not being protected. I declare under penalty of perjury that everything I have stated in this document is true and correct. I would just like to point out before people start jumping up about the image of the gun being from Reddit, that is irrelevant to what he just said. Where the image came from is irrelevant. The only thing that is relevant in this document is that the gun in the image does not appear to be protected as evidence. So the photo, wherever it came from, bolsters BCA's argument that they need a TRO. So good job, social media folks with the federal government. Thanks for posting that photo. Here is the warrant. This is what they applied for. Permission to use scientifically accepted forensic processing techniques to assist the BCA crime scene team in documenting, locating, and/or enhancing forensic evidence. Permission to fully document the scene using measurements, diagrams, photography, and video. Any and all clothing, headwear, handwear, footwear, and personal items that may contain forensic and/or biological evidence related to this investigation. Any personal items, including phone, wallet, keys, or identification related to the subject. Cellular, telephones, and electronic devices capable of sending and receiving electronic communications. All firearms and ammunition. Projectiles and remnants of projectiles. Spent and unspent cartridge casings. Firearm-related paraphernalia, including but not limited to cases, storage containers, holsters, sighting systems, and slings. Metal or powder residue related to the discharge of a firearm. Trace and microscopic evidence, including but not limited to blood, hair, fingerprints, body tissue, body fluid, and excretions. Any other weapons. Permission to deploy and utilize unmanned aircraft systems to assist the crime scene team and investigations in documenting, locating, and/or enhancing forensic evidence. Hopefully, they did do that. The area of 26th Street and East Nicollet Avenue, including the street, sidewalks, boulevard, and curtilage of adjacent businesses. They give a brief to the judge, why they are requesting it, so forth. Okay, and then this is the same thing signed by the judge. And then here is the judge's order, also from yesterday. Again, this all moved very quickly. This is the judge's order for the temporary restraining order. Plaintiffs, Minnesota Bureau of Criminal Apprehension and Hennepin County Attorney's Office have filed a complaint and a motion for a temporary restraining order seeking to enjoin defendants, their employees, agents, and anyone acting in concert with them from destroying or altering evidence related to the fatal shooting involving federal officers that took place in or around 26th Street and Nicollet Avenue in Minneapolis, Minnesota on January 24, 2026. Having reviewed the complaint, motion, memorandum of law, and other evidence submitted in support of the motion and in accordance with federal rules of civil procedure, it is ordered that the plaintiff's motion for a temporary restraining order is granted as follows. Defendants, together with their employees, agents, and anyone acting in concert with them, are enjoined from destroying or altering evidence related to the fatal shooting involving federal officers that took place in or around 26th Street and Nicollet Avenue in Minneapolis on January 24, 2026, including but not limited to evidence that defendants and those working on their behalf removed from the scene and/or evidence that defendants have taken into their exclusive custody. Plaintiffs shall serve defendants with a copy of their motion, all supporting papers, and this order by no later than Sunday, January 25th at 9 a.m. A hearing will be held in courtroom 7D on Monday, January 26th at 2 p.m. regarding any objections defendant may have to this order's entry and whether this order should remain in effect. A TRO is typically 14 days. If defendants wish to file any response or objection to plaintiff's motion or this order, such response or objection shall be filed no later than Monday at noon. This court, in its discretion, waives the requirements for plaintiffs to post bond. So signed, District Court Judge. So again, the Minnesota Bureau of Criminal Apprehension and the Hennepin County Attorney's Office have sued every goddamn body in federal law enforcement involved in yesterday's shooting or the obstruction of these agencies getting access to the scene. This is separate from the mayor and the governor's court action to try and get ICE out. They applied for an emergency temporary restraining order to address obstruction and spoliation, and they have been granted that by a federal judge. And there will be a court hearing in Minnesota tomorrow at 2 p.m. And this document is fucking gobsmacking. We have crossed a threshold this weekend. And there's no going back. Once we cross thresholds, we can't go back. We can only go forward, charting into something new. Every time they kill someone, we cross a threshold. Every time they abduct a child and dangle them to lure their parents out, we cross a threshold. Every time they snatch people without a warrant, violate ongoing protections orders to not use chemical weapons, we cross a threshold. Now we finally have local law enforcement, not governors, not mayors, law enforcement, saying a crime has been committed. That is our jurisdiction. And federal law enforcement is obstructing the law actively. We had a warrant signed by a judge. They would not comply. We have a constitutional right to be there and to investigate. They would not comply. They've already destroyed evidence in a previous case under our jurisdiction. Absolutely breathtaking. It's a stunning, historic document and a historic moment. And these people show a lot more spine than them 7 motherfuckers who voted to increase ICE funding. You can find that video out this morning as well. So this is where we're at. Local law enforcement has to sue federal law enforcement for obstruction of justice, for impeding states' rights. In order to investigate a homicide. My listening library says it's insane that DHS posted their view on what happened defending ICE and then hours later said that they would investigate it. That is insane. It's totally insane. And it's a fucking joke. People were picking up shell casings and just putting them in their pocket. ICE agents took home trophies. That's what they're doing. They're collecting trophies. And just taking them home. Federal agencies are scurrying away evidence. They have Nicole Good's car. Why? You said there was no crime. Why do you have her car if there was no crime? Why do you have bullet casings if there was no crime? If you're so sure there was no crime, why are you denying local law enforcement access to evidence if there was unequivocally no crime? It's fucking bullshit. There is an ICE agent clapping after they kill Alex Pretti. Clapping. they will investigate. That's a fucking joke. They're only saying that because they're getting sued. They're not saying it because of public pressure. They're saying it because they're getting sued and they want to thwart stuff like this. Oh no, we are investigating. Oh no, it's fine. That shit is going to fall flat. I think that the Bureau of Criminal Apprehension and the Hennepin County Attorney's Office are going to be nothing but successful with this action, regardless of what the fuck the feds say. I think they will be nothing but successful in these actions. I don't care if they try to appeal to the Supreme Court. I think the Supreme Court will kick it right back down and tell them to kick rocks. They're not going to touch it with a 10-foot fucking pole. They are not going to touch states' rights to police. They are not going to do that. They're going to be nothing but successful on paper. Even with little stuff like the gun and the photo of the gun, right? It doesn't matter that the photo of the gun came from a previous Reddit post that the feds just Google searched and found and said this was the gun. It's beneficial to their TRO because that gun doesn't look like it's in an evidence bag. It doesn't have the safety, zippy tie lock thing that goes through it. I have one of those for Betty. It ain't got one of those. So either they're incompetent in the preservation of evidence, or they're going to admit on paper in a court filing that they presented a fucking Google image to the public. They look incompetent one way or the other. They look dishonest one way or the other. But even that is a little dig. Oh no, it's not going to stop anything. It's not going to stop anything, but it's its own valid fight. Right? It's its own valid fight. And at a certain point in the momentum of these situations, it's going to matter a whole hell of a lot. Let a local jurisdiction make headway into charging an ICE officer with a felony crime. Let a local jurisdiction make headway into charging an on-duty ICE officer with a felony crime. That will give them all concern. This isn't civil, it's criminal. If you're destroying evidence, that's criminal destruction of evidence. That's a felony. This is short of arresting dude on the spot. As I said yesterday, when you gonna start action? When's law enforcement gonna step up, cross that blue line, and put hands on motherfuckers when they see this shit going down? I still think we're a ways off from that. But this is one of the most aggressive tactics that a state and local law enforcement could take, is accusing them outright of obstruction of justice, mishandling and spoiling evidence in a criminal case. This is the fight that these folks have decided to wage. And I'm not an optimist. I'm a realist. And realistically, given the circumstances, I think that they are going to win every time, every round. I think they're going to be successful. And at the end of the day, that is going to be beneficial to any state that winds up under federal occupation. A pattern begins to emerge. pattern begins to emerge on the court record, not just what we can witness with our own eyes over the past 6, 7 months, but on the court record. So, is it gonna stop them? They'll kill somebody today. But will it catch up with them? I believe that it will. I believe that it will. All it takes is one to cross that line and say, "Fuck it." And now the line is crossed, this threshold is crossed. And it's crossed for everybody in the United States of America. They crossed this threshold for their own citizens, for their own, reasons to carry out the duties that they are required to do in their positions, in protection of constitutional rights, of state rights, of all of those things. But secondary to all of that is for every American, they have done this. And it only makes it easier for other jurisdictions to say, well, we're not the first, and we probably won't be the last. Very powerful. Very, 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 very powerful. We know they didn't appropriately preserve evidence. So even if, the feds called them up today and were like, okay, come over, you can see everything. That evidence has not been properly preserved. It's on. There are so many different and competing. I mean, they're on the same side, but let's be honest here. There are competing interests, competing perspectives, competing levels of willingness, right? You've got Keith Ellison, who is the state AG. He has a liberal mouth, but can often be very conservative. You got this guy. He obviously voted for Donald Trump. I don't care what anybody says. I just don't think he voted for her. I just don't think he did. And Mary Moriarty, she could go either way. The hell, she may have voted for Jill Stein. They look damn near alike. Okay? All of these people in their respective lives, in their respective professions, had to converge at the same point of, we are going to have to do this, and we are going to have to do it together. That's a lot. That says a lot right there. You can't imagine or assume that these folks are immediately on the outset aligned in what the problem is or what to do about it. Right? But they all arrived in the same place on the same day as the killing. They were drawing up this lawsuit before they had gone through all of the steps to confirm Alex's identity and properly notify his family. They refer to Renee by name. They don't refer to him by name. Why? Because they were drawing this up. That doesn't mean he wasn't identified by the public. The AP are the ones that called his parents and told them, asked them for comment. That's how they found out that their son was dead. But it would appear from reading this document that they were in the process of drawing this up while that was all going on. That's early in the day. I'm sure dude, head of the BCA, thought surely the warrant will get us access. I'm sure that was his, like, this is obviously going to work. And the feds were like, get the fuck out of here. And he was like, oh, oh, okay. I could be reading him all the way wrong. I really could be reading him all the way wrong. And I'm definitely projecting a bunch of stuff onto him. But I can guarantee you those personalities exist within that power sphere of local prosecutor, state, investigator, and then state AG's office. Oh, yeah. Oh, yeah. They all got to the same place on the same day and said, this is what we're going to have to do. And we can't go back. And they did it. So they put out a very forceful statement yesterday, said the federal government is lying about their son, and that is enraging and disgusting. And, called on all of us to stand with Minnesota. Democrats supporting the funding of ICE is not standing with the people of Minnesota or the people of the United States, period. Unbelievable. I'm going to be shaking my head about this document for the majority of the day because it really is stunning that we have come to this place. But I do give them mad props for arriving at the decision point the same day. And really, they're doing that because they don't want to give the residents in their cities a reason. Let alone, it's their job to investigate and prosecute crimes. As they said in their pleadings to the court, now more than ever. Now more than ever, the people need to have confidence that this shit is being dealt with. As I always say to lawmakers and people in positional power, when the people start to use the word demand, when that word pops up, demand, you need to start asking yourself, what comes after demand? I don't want to know. I don't want to know. When the people start using the word demand, they have fucking had it. What comes after demand? You better work it out, or you're going to find out. Usually people die. So I will keep you abreast, obviously, of the, of how this progresses, but it's going to go fast. The government is obviously going to file a response, and they're going to have a hearing tomorrow, and they're going to be fighting over this heretofore. But again, obviously I can't say, I guarantee you, local law enforcement is going to be successful. Obviously, I can't do that. But I really think that they are going to be successful in this area. I think they've got everything going for them, and nothing that they are asking for is unreasonable. Because again, they're not saying, "We want to take possession of this evidence, force the feds to hand it over to us." They're saying, "Keep them from destroying it, and we want access to it." So, yeah, we shall see what happens. We shall see what happens going forward. So if you came in late, you owe it to yourself to run it back. Thank you, beautiful. Appreciate you. Appreciate everybody who supported this morning. Um, Run it back, because this is a historic moment. It really is a historic moment, and it should be. The seriousness calls for it to be. Yeah, the seriousness calls for it to be. Remember, wherever there's people, there's power. I'll see you soon. Peace.